One, two, is this on? I didn't intend for Wednesdays to be my discussion on intellectual property laws, but here we are. Third week in a row with this on my mind. So today I'm going to talk about how intellectual property gets licensed and turned into secondary products. Licensing occurs when the owner of an intellectual property grants another business or industry permission to use that property in their manufactured product or combined with their own brand in exchange for a fee or per portion of the income. For example, Monopoly is an intellectual property owned by Hasbro. Marvel Comics is an intellectual property owned by Disney. Hasbro doesn't, well, they sort of make movies. Hasbro doesn't make comic books. So Marvel doesn't make board games. And Disney licensed the Marvel rights to Hasbro, and we get Marvel Monopoly. That's not a very good example. I got one. Before Marvel was bought by Disney in the late 2000s, they licensed Spider Man to Sony to make movies about the character in the late 90s. Sam Raimi's Spider Man came out in 2002, but Marvel executives didn't think movies about superheroes were a good idea, even though Stan Lee had been in California for over a decade pushing the idea, and even though there had been 11 movies starring DC superheroes in the prior 2 decades, earning 6 Oscar nominations. Marvel's owner was still against it. The story goes that Avi Arad, chief creative officer at Marvel, had a custom Spider Man jacket made and wore it to a lunch meeting. He deliberately had the lunch sat in the back of the restaurant, arrived late, and meandered through to get to it, allowing everyone who asked about the jacket to stop him. By the time he reached the table, Sony was on board with licensing Spider Man. Now, I may have gotten two different stories confused there. Feel free to fact check me in the comments. But the bottom line is that Sony bought the license to Spider Man in perpetuity. Sony paid a reported $7 million. I've also seen 9 or 10 million, most often seven, for the rights to the Spider-Man characters for live-action movies and live-action television, so long as they never resell those rights and they release a new feature film every 5 years and 9 months. There is a separate contract to allow Spider Man to coexist in the MCU and appear in movies such as Civil War or Endgame. The rights are specifically not sold to Disney. At one point, Disney did offer to buy the rights back, and Sony was in a position where financially it would be a good decision. But then Disney realized that if they just waited and Sony proved unable to make and release a new movie, they would get the rights back for free soon enough. So, what happens if you make something using someone else's intellectual property and then try to sell it? Well, without their permission and a valid contract, you legally can't. One famous example of this is the fan fiction that became known as 50 Shades of Grey. The novel series 50 Shades of Grey started life as a fan fiction to Twilight named Master of the Universe. Christian Grey was Edward Cullen, Anastasia Steele was Bella Swan. The changes were made so that Vintage Books could publish the work without licensing Twilight from Little Brown and Company, the company that published Twilight. This happens a lot, and honestly, once you're aware of it, you usually can't stop seeing it. So I apologize if this is new information. It does happen most often in the comic book industry, but it's literally everywhere. Uh, but in the comic books, back in the 60s, creators at Marvel and DC wanted to do a Justice League Avengers crossover. The rights couldn't be agreed upon, so both titles did their own 2 issue story, introducing characters surprisingly similar to the current Justice League or Avenger teams. Marvel's Justice League became the Squadron Supreme. I plan on talking at length about them on a Monday to come. DC's Avengers were known as the Champions of Angor and have never achieved any popularity. The practice of skirting around these licensing rights is called filing off the serial numbers and is a reference to black market machinery or firearms. But this also happens when a creator takes their own creation from one company to another. The post crisis Supergirl was effectively created by Peter David. She had existed before under other writers, but when he took over the title, he made significant changes to the character that did make her unique. And when he left DC, he continued that story with comic publisher IDW under the title Fallen Angel. While this couldn't legally be established in the story, he did confirm in an interview with Comic Book Resources, if I'm remembering correctly, that this was intended to be a continuation of that story. Steve Englehart did something similar with his character Mantis. I think she followed him through 3 different comic book companies under different names, but always the same personality, motivations, general storyline, backstory. Steve Englehart's Mantis, by the way, very different from the MCU's Mantis. I highly encourage you to check out the differences. So, how often do you see something in media or marketing and wonder, isn't this just something else with a new name? What are some examples, maybe, of licensing that you think failed to hit the mark? I mean, aside from the obvious example of an R-rated action and violent movie like Rambo becoming a Saturday morning cartoon for kids in the 80s. Leave something in the comments and let me know if you want me to keep talking about intellectual properties or move on to something else.